in particular, this information with you so that you know that it is important to plan. And it doesn't matter what age you're at, if you're the planner or if you're planning for somebody, it's extremely important to plan. My father passed away 3 years ago, and thank goodness we planned and had things prepared for him. But he was at an older age, and so that was more easier to do. But even when you're young, you need to have your things in order and make sure everything is aligned. So as I prepare to introduce Donna, I just want to say thank you in advance to both Vanessa and Donna for being here today. The importance of estate planning is not just a phrase. It is something that we need to really digest and really understand and actually apply it. Because a lot of people hear information and they say, oh, well, that was interesting, but they do nothing about it. And then when tragic things happen, they wonder, oh, what do we do now? And they scramble around and, you know, family is in disarray and one's fighting the other one because they want this and they want that. But here's an opportunity for those of us who are here in person and those of us who are watching online now and later to really understand what we need to do. So before I do anything else, and as I prepare to introduce Donna, I want to just pray. And if you would kindly just bow your heads. Heavenly Father, we thank you once again that you have allowed us to be in a position to learn. We are so thankful as well that you have provided resources for us to learn. And so today, as we sit together and we listen to what is being said from our facilitators, I pray that something will be digested in our hearts and something will move us to impact our lives in a positive manner. I pray that you would enlighten the facilitators, that as they share, they will be able to get the message across clearly to us so we'll be able to apply it as needed. For this we give you thanks. Bless our time together. In Jesus' name, amen and amen. I'm going to introduce Donna. Donna's been in my life and my wife's life for almost 30 years. She looks younger than she is. And she's been a very, very positive impact in our lives. Every real estate transaction that we've had to do, including this church, in particular, Donna has taken care of us. And so we appreciate her and we thank God for her. I want to just introduce her, and I want you to put your hands together for Donna at this time. Donna.
Good afternoon, everyone. How's everyone doing? Good. I'm so happy to see you all here today. It's such a pleasure to welcome you all here today on the importance of estate planning as an essential aspect of securing your financial future. Again, we're grateful for your presence. Before we begin, I would like to extend a heartfelt thank you to our gracious hosts, Reverend Coleman and Lady Anna Maria Coleman, for inviting us here today in this beautiful place and for recognizing the importance of the work that we do. Both Reverend Coleman, as he mentioned, and Lady Anna Maria are very special to me, and we do go back a long way. I am grateful for their continued support and friendship. So both Reverend Coleman, as you know, he mentioned in his speech, has seen firsthand how many individuals in our community are often unprepared when life changes in an instant. Whether lacking of a power of attorney, being unfamiliar with the probate process, or all of a sudden finding themselves as an executor and having no idea where to begin. They understood that estate planning isn't just legal paperwork. It's about protecting your future, your peace of mind, and most importantly, your loved ones. Their commitment to bringing this information to the community is something that I deeply admire. When they first reached out to me, they knew of my work with seniors and their families, helping them navigate important life and housing transitions. They also knew that I'm affiliated with a trusted network of professionals dedicated to serving the unique needs of the aging Canadian. So, by way of introduction, I also hold a unique designation as a lifestyle 55+ Master Seniors Realtor, a distinction held by only 40 realtors across Canada. I have proudly served my clients for close to 37 years, and through my work, I have seen time and time again how critical it is to plan ahead. It does ensure peace of mind. It does reduce stress for your loved ones, but it also ensures that your legacy and your final wishes are respected exactly as you intended. So, today, it is my great pleasure to introduce our guest speaker. Wills and estate lawyer with Devry, Smith and Frank, Vanessa brings a wealth of experience and compassion to her practice. She's personally helped me prepare my own will, and she has assisted many of my clients with everything from comprehensive estate planning to navigating. Vanessa has dedicated her career to helping individuals and families understand their options and make important decisions during some of life's most emotional and challenging times. Her expertise and her genuine care for her clients makes her an invaluable resource for everything that goes with estate planning and administration. So, without further ado, join me in welcoming our guest speaker, Vanessa Romanino.
So good afternoon, everyone, and thank you for coming out on a Saturday to hear my presentations on the importance of estate planning. This is an area of law that is very near and dear, and also to Reverend Coleman and Lady Anna Maria Coleman for having me and welcoming me here today. So as Donna mentioned, my name is Vanessa Romanino, and I'm a lawyer and partner with Devry, Smith and Frank. We also operate in Durham under Woitzik Polsinelli Lawyers and Mediators. Our firms merged in September of 2020. So with this merger, we are now happy to announce a range of services for our clients. So whether that's real estate planning, corporate law, immigration law, we can cover all of those areas, as well as having offices, I want to say everywhere, but 2 in Durham, York, specifically Stouffville, Toronto, Barrie, Haliburton, Midland, and Collingwood. So I was actually thrilled to join my firm roughly 9 years ago as I was moving from a downtown Toronto firm where I focused in competition law. And what I found that I was missing was clients. I wanted to deal with people and not corporations. And that's just what I got with this firm. We still maintain a family feel, which is very important to me, and I think that that comes through in the services we provide to our clients. So as we start with estate planning, let's get right into the presentation. And I would encourage you to please ask questions as they come up, because I feel like these presentations, when they become more of a conversation and a dialogue, we get more across. It's not just me speaking to you, we can have an open conversation about anything that you want to know. So please don't be shy. So as we jump into things, as lawyers, we have to start with our disclaimer. This presentation provides only an overview and does not constitute legal advice. So viewers are cautioned against making any decisions based on these materials alone. Of course, cases are very specific to the facts, so I would encourage anybody that has any questions to please seek legal advice. So what is estate planning? Estate planning is a process of arranging for the management and distribution of your assets and property, both during your lifetime and after your death. It includes several aspects: preparing your legal documents, that could be your will, your powers of attorney, your asset management. In estate planning, we go through your assets in detail. We want to make sure that you understand what assets will be part of your estate and what won't, what is going to flow outside of your estate completely. And that also includes working with third parties, financial institutions, investment companies to ensure your beneficiary designations are made, or even tax planning. We work with accountants. We want to make sure that you understand the tax consequences to your estate. And of course, we want to make sure that we are lessening the impact of the estate taxes when you pass away. We address incapacity, so ensuring that you have appointed a substitute decision maker for yourself in the event that you are unable or become incapable. And of course, providing for your loved ones, ensuring that your assets flow how you intend them, and providing for spouse, minor children, or persons that could be suffering from any disabilities. So as you can see from all of the aspects we cover in estate planning, you can see why it's so important. A good estate plan will decide, among other things, who will receive your assets. You will choose an executor that you trust to carry out your wishes, reduce stress and confusion for your loved ones, and ensure everything is handled legally and efficiently. And most importantly, it will help avoid unnecessary delays, surprises, disputes, and even legal costs. So take, for example, something that I am currently working on, and yes, I do have the consent of my client and encouragement, actually, to discuss this. So, and it's to help understand the importance of estate planning. So, a client prepares their own will. They did it with an online form. She has only one child and thinks she has done everything that she needs to do, and she saved money. But it was signed incorrectly. And it actually did not dispose of her estate. So what now? So now I have to make an application to the Superior Court for an order for substantial compliance, and I have to seek an order to have that estate disposed of pursuant to the succession laws, because she's not disposed of in the will. So these are additional costs. These are additional court applications that we would not have to do if there was a properly executed will. Okay? The good news with that is that the law has changed to now allow substantial compliance, because that was not always the case. But again, we're looking at delays. We're looking at increasing an already hard time on a child that has just lost their mom, and legal fees, of course. So what are the mechanisms that we use in estate planning? We use wills, powers of attorney, that's both for property, so mainly relating to your finances, and personal care, so your living and accommodation, your food, your hygiene, your treatment, trusts, and tax planning. And we'll get into these each in further detail throughout the presentation. So to start, we have the will. A properly planned will is extremely important to clearly communicate your wishes. The will provides a clear way for you to ensure that your loved ones are provided for and that your assets are protected. This is a legal document that outlines your wishes for the distribution of your assets after your death, and it can address many important factors: guardianship of minor children or potentially disabled family members, funeral and burial preferences, and other personal requests. It's important to pass away. And in later slides, we will look at the impact of not having a will. Another mechanism that we use is multiple wills. So you can have more than one. A common example of this, so the courts have approved using multiple wills as effective estate planning. A common example of this is we have a primary will that will deal with your assets that are subject to estate tax. Typically not be subject to estate tax. So that is used a lot in shares in private companies. It can be used for household goods and personal items, and it can even be used in some real estate. So it moves assets into two estates so that when we have to probate the first will, we probate will number one, we pay estate taxes on that first will, but we are sheltering whatever we can under that secondary will. So preparing your will. Of course, we cannot cover all considerations when preparing your will, as these can be very specific to your individual needs and situation, but we will. So, naming children as estate trustees. I'm always shocked that clients ask me, number one, can I do this? Well, the answer is yes, But it's important to remember that your estate trustees are entitled to compensation can be up to 5%. The courts will look at several factors in determining what is fair and reasonable compensation, and that's the size of the estate, the expertise of the estate trustee in administering the estate, the successful administration of the estate. So this compensation can be waived, but don't assume trustees. Your other children may distrust how the estate is being handled. It is important to be honest with your lawyer regarding the different family dynamics and how you intend to distribute your estate. Dependent support claims. If you are supporting a dependent at the time of your death, they can seek support. This is legislated for. The court takes moral obligations very seriously. And if there is a dependent, they may make a claim and your wishes that you intend in your will might not be carried out. So when probate is triggered on an estate, we have to pay estate tax to the Minister of Finance. We only exclude, so we pluck out assets that you hold jointly. You own them with somebody else. So for example, you have a bank account that's joint. That does not form part of your estate because it goes to the surviving. An RRSP, tax-free savings account, a life insurance policy. If you have named somebody directly on those, it will flow outside of the estate exactly how you've named it. So why is this important? On that total value of assets that we determine, and the estate tax is 1.5% of the total value of your estate above $50,000. So we get a break on the first $50,000, everything above that will be subject to the tax. So let's look at some potential strategies to reduce estate taxes. So transferring the property while still alive. An option in estate planning is to name personal property. This could be between spouses. You must be cautious, however, in giving beneficiaries title to your property before you die. There is a potential for loss of control, loss of ownership, creditor risks, and beneficiaries using your money or property improperly. So a common question that I typically get asked is, my neighbor told me I should add my child to title to my property. Very common question. And yes, you can. Yes, you will avoid the estate tax, but there are implications. Now you've added them as an equal owner to your property. So again, you've lost ownership, you've lost control. If you ever wanted to mortgage, lease, you need their consent. Creditor risks. If your child has any issues with creditors, now that will be an asset of theirs as well, and they can claim against that. A big one is capital gains. They will be subject to a capital gains that could be much greater than the estate tax. Okay, so it is very risky. Where we have real property, real estate, a joint tenancy creates a right of survivorship. So if one party passes, the property will go to the surviving owner. This is different from a tenancy in common where each party owns shares. So you could still both be on title, but you each own, let's say, 50%. Your 50% comes into your will, and it will be distributed in accordance with the will, and likely be subject to estate tax. If it's joint, it will just pass to the surviving owner. In Ontario, the courts have found that a joint tenancy between a parent and a child that is not independent was not intended, and it actually creates a rebuttable trust in favor of that parent's estate. So what was happening is parents were putting, for example, a child on bank account. It's not that they intended that that bank account would only go to that one child and not their two other children. They were really just on there to help out. So that's not a true right of survivorship like I would have with my spouse, where if something happens to me, we're both contributing into that account and I intend for everything to go to them. So again, in doing that, you're creating challenges and potential. So it's very important you meet with a lawyer to understand all of the implications of your decision. Naming beneficiaries. So assets that have designated beneficiaries, so again, registered investments or insurance policies will flow outside of the estate, again, directly as you name them. These would only be included in your estate if there was no beneficiary, the beneficiary is listed as the estate, or a beneficiary has passed away. So a common question I get is, why would anybody name the beneficiary as an estate? Well, it could be that you have minor children, so they can't receive that gift just yet, or maybe there's disabilities that you have to plan for. You want that to come into your will because you want to create a trust in your will that's going to manage how that money is dealt with. What happens if you do not have a will? So when you pass without a will, it's called dying intestate, okay? I always find that people are shocked to hear your estate does not automatically go to your spouse. Okay, so we must look at the legislation to, number one, determine how your assets will be distributed, and number two, who can be appointed as your estate trustee. So, when you pass away without a will, your spouse is only entitled to what we call the preferential share. So, if you died after March 21st, this would be $350,000. If it was before, it was actually only $200,000. After that, the spouse and children would split the estate in respective shares. Okay, so I find people are always shocked about that. They think, well, if I pass away, no, everything will go to my spouse. That's not the case. Also important, more so now, I think more common law partners are not considered under our Succession Law Reform Act. So if you are living common law, most people think, we're together, we're married, that's my spouse. The legislation does not consider them. So if you pass away without a will, they will not be included. Implications of separated spouses. So this is another recent change in our laws, who are now recognized as of January 1st, 2022 to be excluded. However, the legislation is not retroactive. So that means only after January 1st, 2022. So I've had instances where people separated 20 years ago and they just never filed for divorce. They split up their assets. And now I'm trying to settle an estate and this spouse has a claim against the estate. So imagine the hardship on the family trying to track this person down, getting them to renounce their right to apply and renounce any entitlement that they would have. Who manages the estate? So the Estate Act dictates who can be appointed as anybody who is a married spouse or person living in a conjugal relationship with the deceased at the time of their death or the next of kin. Okay, so there's not an automatic. And then again, let's say you have appointed through the court. So again, we're looking at time costs. Also, where you don't have a will, there is an administration from the courts. So the easiest way I like to put this to people is an administration bond. When you think of criminal cases, you post a bond and the court wants you to post a bond so that you come back to court. On the estate side, they want you to post a bond so that you properly administer the estate. They want to essentially make sure that you don't take those assets and run. They want to protect against those financial losses to an estate. A bond is required to be filed where the deceased died without a will. The deceased died with a will, but the applicant, the person applying, was not named in that will, and died with a will but was not a resident in Ontario. Okay, so this is important because it has significant implications. The bond can be 2 times the value of the estate. So very significant. They would have to put that up against a house, something like that, or we would have to seek an order from the court to dispense with that requirement or lessen the amount of the bond. Selecting your estate trustees. So now let's look at some considerations when preparing your will. One of the most important decisions you will make is who will act as your executor and trustee. So this is the person that will be responsible for collecting your assets, preserving them, maximizing the profits to your estate, settling any of your debts or liabilities, and then of course distributing your assets in accordance with the will. It is also important to note that this trustee will be responsible for managing any trusts in the will. For example, trusts for minor beneficiaries or any person suffering from any disabilities. So considerations that we should look at in choosing your executor. Does the person live in Ontario? This is important given the logistics to administer an estate and the potential to trigger the requirement for posting that bond. Consideration should be given to whether any trusts are required for minor beneficiaries or persons with a disability, because this is the person that will manage those funds. Is the estate complex? Are there their business interests? Would it be more beneficial to have a trust company managing the estate? Do your children not get along? More considerations, as we previously touched on the estate trustee and their role for minor beneficiaries. I want to just highlight that these are discretionary trusts that we put in the will, testamentary trust. Discretionary, meaning that the trustee has the discretion when, if, and the amount that is paid out of those. They are managing that trust, so they have to be trustworthy, but it also has to be somebody that you have confidence that they will do that properly for the benefit of your child or, again, somebody suffering from a disability. If you want to name multiple executors, we need to consider, can they work together? We always recommend naming an odd number, and then we include what we call a majority rule clause. So if there is a disagreement, the majority vote will win. Otherwise, do we need to appoint an umpire to settle any disputes? So those are all considerations that we look at when you're choosing your executor. Some special considerations that we consider in your will is getting full legal names and providing accurate family relation. So my niece and nephew are not my spouse's niece and nephew. So we have to accurately define the relationships, planning for minor beneficiaries, so including a trust. If there is no trust in the will and a beneficiary is under the age of 18, the funds may have to be payable into the court and then managed by the court and then released to them at the age of 18. 18 is pretty young for a beneficiary to receive a lot of money. So in the will, we allow you to determine what age they will, and that will vary depending on the specific child. Custody and guardian for minor children, appointing somebody to have custody of your guardian of property, and then planning for persons with a disability. So where somebody suffers from a disability and collects ODSP, Ontario Disability Support Program, that is based on a financial need. So any inheritance that they receive could disqualify them from receiving that government benefit. So in that case, we include in trust, and that beneficiary does not have access or control over it, because again, the trustee is going to be managing it and giving them payments out of that trust. So now we can switch gears and look at what are powers of attorney. So like I said, a will takes effect when you pass away. Your powers of attorney are your living documents. These are documents that you are creating while you are alive, and you will essentially appoint a substitute decision maker for yourself. So we have two types of power of attorney. We have power of attorney for property. This mainly deals with your finances, and your power of attorney will be able to do anything you could have done if you were still capable except make a will. Then we have your power of attorney for personal care. So again, living and accommodation, food, hygiene, treatment. If you cannot make those decisions for yourself, you are appointing somebody to do that for you. Who is the right power of attorney? So many of these considerations are similar to those as we consider when we are appointing an estate trustee or executor, but we'll look at a few here. So age and mental capacity. So power of attorney for property, individual must be 18 years of age. For personal care, 16. Trustworthiness. Your power of attorney will be able to do anything you could have done if you were capable. You're appointing somebody to step into your shoes and make all of your decisions for you. So you need to ask yourself, do I fully trust this person to act in my best interest? Are your affairs complex? Do you need a professional to be acting in this role? Location. You can appoint somebody who lives outside of Ontario or Canada, but this may cause practical challenges. Travel, legal delays should be considered. The number of attorneys. You can appoint more than one and act together jointly or separately. And appointing two people jointly generally creates a level of protection because we need two people there to consent and sign off on decisions. But more than that, is it going to be difficult for them all to get to the bank to sign off on something? Okay, so we need to consider those. And then restrictions for any power of attorney for personal care. You cannot appoint somebody you pay to provide services to a relative. And then we get into probate. So I'm always curious when I start off these presentations on how many people are familiar with the term probate. You hear it? Yeah, you hear the, no, not at all. So probate is a process where we actually have to hand in the will to the Superior Court. So we give your will into the Superior Court, and essentially the court validates the document. So what that does is it gives any third party that's relying on that will security. So it will give the bank security. So if you look at an example, you're named as an executor in your late aunt's will. It's you and other nieces and nephews. However, your aunt had a prior will that named her friend, who was the executor, and the friend was the sole beneficiary. So the bank, and the bank gives them all the money. Now we have a problem, because now there's a will that happened after that, right? So having probate gives that security to the bank, to those third parties. And again, it's the process that it gives the authority to the estate trustees to act with respect to your estate. And probate ensures that assets are transferred in accordance with the will or the Succession Law Reform Act, the legislation. So when is probate required? And on the assets owned by a deceased person at the date of death. It is important to remember, again, that your estate is everything that you own at the date of your death, but we will exclude assets that are joint or assets that have a beneficiary. So solely held assets could trigger that requirement for probate. For financial institutions, this typically would be in and around $50,000. However, this is not a hard rule. I've seen it at much less. Also, we need to consider factors today. People are tending to get married later, so they're coming into marriages with assets. So you come into marriages, couple gets married, they move in, and they don't realize that this matrimonial home is still in one name. That will trigger probate, and then we'll have to pay estate taxes. I always am surprised that people will come to me and say, but I have a will, probate isn't required. And that's not the case. A will does not dictate whether you have to probate or not. It's the assets that you own at the date of your death. We have what's called a first dealings exception. This is a very narrow exception, so I'm always hesitant to even highlight it. But what it means is if you purchased your property in the old registry system, and you don't need probate. The problem is that no other asset can trigger probate. And if another asset does, we are still making the application, we still have to pay the estate tax. So essentially it's considering a situation where you only have a house, you pass away, you've owned it for years and years, and it qualifies. Okay? And in some cases, we would recommend doing a secondary will. So for example, if there was a cottage that you've owned for years, so we can try to shelter that. So that would be use of a multiple will. Steps involved in probate. This will vary case by case, but some of the steps that we go through is we file the application. So the executor submits a probate application to the Superior Court. We include the will and supporting documents. We have to give notice to all of the beneficiaries. The court reviews the application and hopefully issues the certificate of appointment of estate trustee, which gives the trustees the authority to then manage the estate. And then, of course, the executor gathers the assets, pays the debts and liabilities, and distributes the estate in accordance with the will. It's always recommended to our clients that they seek a clearance certificate from CRA to ensure that there's no other tax obligations. Because one of the estate trustee's duties in administering an estate is to satisfy any outstanding debts owned by the deceased. An estate trustee who's aware of a debt or a claim but distributes the estate may actually be personally liable to that creditor. There is no requirement in Ontario to advertise for creditors. However, we generally recommend that clients do so that they can get the protection under the Section 53 of the Trustee Act. So specifically, that section provides that on expiry of notice to creditors, the estate trustee may proceed to distribute the estate. The notice does not, of course, distinguish the debt, but it removes the personal liability to your estate trustee. And then finally, the final accounting. Prepare detailed accounting of the estate assets and liabilities and share that with the beneficiaries. So estate tax, again, whenever we submit for that probate, we have to pay It is important to note that once probate is issued from the court, we now have an obligation to issue or to file an estate information return. So why this is important is because this is subject to audit. So now it's placed a burden on the estate trustees to ensure that they are doing their due diligence in reporting accurate numbers for the value of the estate. So for example, where we have real estate, we always recommend 3 opinion letters from agents, and we take the average, okay, because you are subject to audit. If the estate does not have funds to pay the taxes, we can make a separate application to the court to defer those taxes. Increase legal fees, and it is not automatic. So that is my presentation for today. Does anybody have any questions?
You.
Yeah.
So that was great. So
Thank you.
how do you protect, or what's the best way, if there is a single parent, how do I protect them? And then, or is there a way?
So we would look at all of those mechanisms. Like we would sit down with the parent, of course, because the parent would be the client. We would run and see what they had and see where we can lessen the impact. Like I said, if there was only one child, could we join the asset? Depends. Does the child live in the property? We want to run through the investments. One of the ones that I find creeping into estate law is the tax-free savings account. I'm having to probate wills all the time because people don't realize they can name a beneficiary and they haven't. So we run through all of that to make sure we have beneficiaries. So even if we do have to probate, best case scenario would be that we might be probating one bank account and a house.
So if we were to come to you, the lawyer, and you took that all into for real estate or tax-free savings, and then put it all in what you think would be appropriate for the client, would that eliminate the probate, or there's still a chance?
There's
that you
still a
might
chance
have-
depending on the assets.
Okay. So even if we've given you everything, there's still a small chance that,
Probably a likely chance.
a likely chance.
Usually, probate between spouses is typically avoided because your assets are joint. You're joint on your bank accounts, you're joint on the house, you've named your spouse as the beneficiary, but when assets flow onto children, that's where it gets tricky, and that's where we always see the probate process happening.
And is there a length of time that probate usually, or it varies from forever?
Varies from court to court, so you have to file where you lived at the date of your death. I'm happy to say here in Durham, they do phenomenally. I would say 3 months. Toronto, probably over a year.
So with that 3 months, let's say, you can do nothing with the property, you can't sell it, you literally just keep paying the bills or taxes.
You can sell it, but it has to be conditional on probate. Because what happens is, you need probate to be able to sign off and sell the property. So if you sell the property and you have a closing date of June 30th, and you don't have probate, now you're in breach of contract, and you're liable. So if you put a condition in there saying, I can extend this deal if I don't have probate, then it's okay. But otherwise, no.
And there's no such thing as putting the house, the property in trust for your child. Like, I've heard that, I don't really understand it.
Yes, so I hear that often too, but you have to understand trusts are generally created for very large estates, and there's many reasons for that. Because essentially what you're doing is you're moving all of the assets into a trust, and then you are creating multiple wills. So number one, you're looking at the legal fees and creating an actual trust. Now we have tax obligations, so that trust has to file taxes yearly. Then you're creating multiple wills.
Yeah, there's no word in the tax.
I mean, it's the government.
But in the best case scenario, if it was all put in place by a lawyer, you would just be paying that 1.5 or.
1.5 above 50,000.
Right, so that's the best case, or the worst case, depending on how you.
That's the best case in the sense if we properly plan. Like, I hate to see an estate come onto my desk where I'm doing probate for a tax-free savings account. Right, because it can be avoided. If you would just sit down and go through the assets, ensure that the beneficiary's there, I wouldn't have to be involved.
Right. And we do that with a tax-free savings account, you do that through the bank, or that's literally?
Through the bank.
Yeah. Thanks for so responsible.
Yes. it's done through the bank.
Okay.
But a lot of times, like people sometimes, we have an intake form that we give our clients and people say, I don't want to fill this out, it's 10 pages.
Right.
And I say, just work through the first 5 pages. Just give me your personal information and give me an overview of the assets. And they say, well, why? You don't need that. But this is why I need that, so that I'm flagging anything like that or catching it. And then once I meet with the clients, I say, thank you. This forced me to actually go through. I had a work life insurance policy and I didn't realize I still had my parents on there. I've been married for 15 years.
Right.
I got a weird question. So, I got a pension, right?
Mhm.
And under my pension plan, I have my 2 kids and my beneficiaries. Now, let's say I do a will, and for somehow, when I'm making the will, I change what's the structure on my pension plan. And instead of 50-50, I do 40 or whatever, you know what I'm saying? Which one carries the weight? Which one is the one that actually legal?
So typically, I would recommend that if you were meeting with me, I would say go to your provider and update that. So it should be your pension plan provider, because I don't want that coming into the estate.
Right.
I want it to flow exactly how you intend it, so that we're not getting caught up in estate taxes. You are intending to leave an unequal distribution among your children, there are additional steps that we take to ensure that your wishes are carried out. Whatever the reason you have, we want to ensure, like if you're saying I want one child to have 70%, the other to only have 30, and these are the reasons why, I typically will have clients sign a declaration under, no, that's wrong, or something, we're protected. We have an, evidence in the file.
Well, I know the kids equal, I'm just asking you a question.
Okay, another question. If you said, you mentioned that you have to pay creditors, so if you're the executor of someone's will, and I do what I think I'm supposed to do, so I pay their property taxes or whatever, then all of a sudden, and we then disperse the funds, then all of a sudden there's a credit card bill or some sort of outstanding loan that we didn't know about.
So that's why we recommend advertising for creditors. It's relatively inexpensive for the protection it gives you.
What does that mean, advertise for creditors?
So we post an ad, it's called Notice Correct, and it will say this person died in Durham, this was their full name, this was their birth date, this was their date of death. Any creditors must give me notice in 30 or 45 days. And what the legislation says, that once you've done that, you're free to distribute. You won't be personally
So all of a
liable.
sudden, if I find out they had a car loan for the Ferrari. that
You
they-
could be personally liable.
As long.
Because your
unless-
duty is to ensure that there are no other debts, including income tax
But
liability.
if we put that, if we put the advertising out, you're good.
Yeah.
Well, that's great.
Does the advertising cover income tax liabilities as well?
That's the clearance certificate. Yeah, that's CRA clearance certificate. That will say no taxes are owed. Creditor debt will say no, after 30 days, you're free to distribute. And I think the advertisement is like around 200. So it's relatively inexpensive for the peace of mind. for the clients.
So if you co-sign for a family member and the person died and didn't make a will,
So you co-signed on like
and
a
house.
co-signed, so it would depend on how you are registered on title. So what I'm saying now on the real estate is, a child apply for a mortgage, so they own 99% and the parent owns 1%. And that's just to get the financing. So if that person died, their 99% is going to percent. So typically I draft wills where a client will tell me, oh, by the way, I am on title for my son's house, but that's his house. He pays the mortgage, he does everything. And we gift that 1% to that specific child. Yeah, we can't,
Because there was a situation and we didn't really understand anyways, because we did just came here a couple years after and we did that for a cousin to pass away and it was a big problem with the daughter. More than not, because they were moved.
Oh, okay.
So they put the money into trust fund.
Mm-hmm.
Yeah. And they sold the house and put the money over there.
Yeah, because it would have gone in accordance with the succession laws, because there was no will.
Yeah, from what I'm listening, you know.
Yeah, and there's a sequence, so it's spouse to that person and children, and then if there's no spouse and no children, then it goes to the parents equally, or the survivor of them, if one parent has passed away. Then it goes to brothers and sisters. So I had a situation where there was no spouse, no children, parents both deceased, and there was 3 siblings, but one was a half-brother. They didn't even know where he was, but he was entitled to the 1/3 of the late brother's estate. And of course, we had to track him down. Similarly, if a sibling had passed away, their share would then go to their children.
So if a sibling passes away, that share goes to their surviving children.
If in accordance with the succession laws. But again, if you have a will, like I doubt that this individual would have wanted this half-brother to share in his estate because they
Right.
hadn't seen him in 20 years,
Yeah.
they didn't have a relationship. If he had done a will, that would have been protected.
So the message is.
Yes.
That's the message.
And whether you just came here or not, it's so confusing.
I
It doesn't matter. It's just hard.
Can you explain what inheritance tax looks like?
So that's the probate, the estate tax. So we don't have an inheritance tax in Ontario, but it's the probate tax that the estate pays.
I've
Yes.
had situations where a divorce happened.
Mhm.
Divorce. Mother, father, and 2 kids.
Mhm.
And both parents own a home. Their parents, I want to give my house to my daughter. And my wife wants to give it to her son. And then unforeseen issues in that situation.
So you have 2 children or just 1?
2 children.
2 children. So I generally don't recommend equalizing assets between children. The best case scenario would be that you and your former spouse both leave your houses to both children. Because what happens if you've done that and left it to only 1 child, and then your former spouse changes their will or remarries, and that becomes a matrimonial home. So there's implications there. Or the value decreases significantly and, something happens, it's tricky. That's the importance of estate planning.
That's right.
Spend all your money. Any other questions?
I have another question. This one's for a friend, and it kind of maybe goes to that one too. So I just want, because she's so
This
misguided.
is information only,
Yeah,
not
just
legal
so.
advice.
Disclaimer.
Right, well, because you get, everybody's a lawyer without a degree, right? So everybody tells her what to do. So her husband passed,
Mhm.
and then after her husband passed, his father passed. That was her father-in-law. So that father-in-law, he had 2 kids. And so now the one brother has taken over all of the money. And the share that her husband should have gotten, that should have gone to his kids, that surviving sibling isn't giving it to her. So now he's just sold a house for $1 million and he thinks
He lived in the house that the father owned.
Was he joint on the house?
no.
Or did he have a will?
He had a will and he left it to his 2 sons.
Okay, so then,
One son's
so,
passed.
but the one son that passed away, he did survive his
No, he died a month or so before his
before.
father.
So it depends on how the will's worded. A common contingency would be that if my child passes away before me, their children, their linear descendants would get what I would have been entitled to. But that's not always the case. The
Right.
father could have said, I don't want it going that way, I want it to the surviving child. It would depend on how the will is worded.
She knows, I don't know, of course. Because that surviving son is just not sharing his use. So
He
he
has-
assumed, he
He
just
has
wants
the
it.
will, right? He has the will.
So probate would likely be possible because there's a house. So you can always check with the Superior Court in that area because that's public
So
record.
as soon as the house sells,
So he would have, so if you're named in a will,
yeah,
that's what leads me to believe he was not named. You have to serve notice to the beneficiaries once you're probating. So they get a copy of the will or the portion of the will if there's a specific gift only. You get that page or the entire will if you're a residual beneficiary, and then you get a copy of the application. So if he wasn't served on that, it's likely that, I can't say without
Yeah.
searching title, but it's likely where we have real estate, probate is required. So he should have been served. Yeah, so Toronto Superior Court, you can call or email them.
okay.
Yeah, it will take you a while to get through, but
So for clarification here, who has the right to actually see the will?
the beneficiary.
And how do you get it if they don't want to give it to you?
I mean, you could always send them a letter. Or the portion. The rules have changed now where we actually have to serve the entire application, which I don't necessarily agree with. Before we would serve them with just a notice. Now they receive the whole application, so they get a full list of the asks. Well, not specific list, but they will know. There was a house worth $1 million. There was personal property worth $500,000. So if somebody's only received a small cash gift, you know, they received $500, now they're seeing what the estate is worth in the entire application.
Anything else? She's a question about this reverse mortgage.
Oh, the chip reverse charge?
Reverse mortgage.
Yeah.
How, do you have an idea?
So I'm not really primarily colleague Bob here in the audience, who is one of our real estate lawyers.
Sure. I snuck in. In your house, and instead of you paying the mortgage, it pays you every month, and you can arrange what that amount will be. And you're usually using the equity in your house in order to fund your living expenses, so that you can stay in your house. It supplements what you would get from kind of a pension or old age pension. So you know that bumper sticker that says, "I'm spending my children's inheritance"?
Yeah.
That's what a reverse mortgage is. It's not a bad thing. It's very practical. I might use it someday. I've already told my children that my will is very short. It says, "Mom and Dad spent it all. All you're getting is your education and your good looks." I'm going to stop now.
If there's no assets like a house or anything like that, what kind of things do you need to make sure that you put in your bill? Like, does it include like bank accounts, like beneficiaries for bank, like does that have to be specifically listed?
No, we don't. Unless there's a reason to. So like I mentioned earlier, like you are on 1% for mortgage purposes, and you have to give that property only to one child. That would be a reason that we would specifically list that property. Or, you know, you had an account that was really your child's account and you wanted to gift it to them, but otherwise we don't put in the specific assets. You would be in all the time updating your will. We usually will dispose of personal items, your clothing, your furniture, your jewelry, if you had reference a letter of wishes, which gives you the option to just create that letter and change it as you please. And then everything forms part of what we call the residue. So the easiest way that I like to explain that, it's the remainder, what's left after debts are paid, and that's how you are directing it.
What happens with things like old age pensions and stuff, like pensions and things like that?
So they're usually canceled by the funeral.
Okay.
But there is some money in the bank account. And so he doesn't own anything, but he's got,
So that's still property,
that's property.
personal property. So real property, real estate, bank accounts, cars, goods, those are personal property.
Oh, okay. You still get a will for that, even if you don't own the house.
Even if you don't have anything, it's always recommended to get a will because, you know, who can talk to CRA to close everything down? It becomes very difficult for somebody, if there isn't a will, to properly handle things, even where you don't have significant assets.
Even making funeral arrangements, you can't do. Like a lot of them will ask to see the will.
So how young would you recommend a will be made? Like young people at this time particularly think, oh, I don't need anything like that. What age would you recommend?
I always say, so I actually find it opposite. I find that young people are coming in all the time. It's the boomers that I'm having trouble with. You know, my parents were included. It took me forever to get them to do a will because there was this no background, and it was like, if I do a will, something bad is going to happen. And if they don't, I always tell clients, you need to consider it like car insurance. You don't take out car insurance hoping that you're going to, or thinking you're going to get into an accident, but you want to be protected if you are. But otherwise, you know, when you have assets, if you're working a full-time job, you have a bank account, you own property, even if you're 19 years old, you should have a will.
And then you can update it as you...
Yeah, it's meant to be a fluid document to change as your life changes.
How hard is it to change, like, to, if you have a will and then it's like really old? Because I have a will, but it's very old. I don't have little kids anymore. How hard is it to, like, do you have to do like the whole process all over again?
I mean, generally with myself, if you were coming to me and it wasn't a will that I had drafted and you were changing a significant amount of it, you mentioned your kids were younger, so I would assume that most of the will would need to be changed. It would be cheaper to just do a new will.
Okay.
And the first will becomes null and void.
Yes, it will be revoked as soon as you sign the new will. Well, we hope. Perfect, thank you.
Guys, we have copies here of the PowerPoint presentation. Would you like to take? That's great. Let me distribute some of it.
And I don't know, Donna, if you want to take any questions, if you have any questions for regards to real estate, you can feel free to ask Donna those questions. But before you leave, we have refreshments in our hall that we would like to share with you. And so we don't want you to just head out without anything to be refreshed. So if you don't mind joining us for refreshments, that would be nice. And as we're closing out our live stream, we checked to see if there were any questions that were online, but there were no questions online, so we couldn't shoot those to you, Vanessa, but perhaps later you may get some questions, and I hope you don't mind if we forward them to you. Okay, thank you. Thank you so much. So we just want to say thank you very much to Vanessa for presenting today. Put your hands together for her again. We appreciate you, and we thank you for sharing. And Donna, thank you for sharing Vanessa with us as well. And all the questions that were asked, thank you for participating. It was very informative, and I hope even those who are watching online, because there was quite a few people online watching, that they will receive the information as well and make the choice to get their wills done, because it's important. It doesn't matter what age, because some people think, oh, it's when I turn 60, I'll write my will and I'll put everything in there. But keep that in mind. It's important. A will is very important. So as I just want to say everyone who participated, even those who delivered flyers, those who set things up, I just want to say thank you very much. It's very much appreciated. And I know, let me say this, the information that was shared today will stay online and people will be viewing it. So, Vanessa, you may get some calls. Be ready to get some calls, and people are going to be interested in doing their wills. So I appreciate that. And I also appreciate your colleague coming as well. Thank you so much for coming and answering questions as well. Much appreciated, and everyone else who came. So if we could just stand at this time, we are going to close out. And I don't know if my wife has anything to say. No, she has nothing. Yes, she wants to say thank you as well for coming. So let's just conclude in prayer. Father, we thank you again for this time that was well spent. The information was very informative and very engaging. I pray that you would help us to be responsible, to make those key decisions, to get our, not only just our natural business fixed, but even our financials fixed, that when that day comes, we will be ready and leave nothing behind to cause disarray. I pray that as we leave this place, and even as we fellowship a little bit, having some refreshments, that we will find it very thoughtful and very educating. We thank you again for this opportunity to learn, because we have come and we have learned so much. The education of this has presented to us that we have homework to do. So I pray that each person will take some action and make their lives better and their family lives better. For this we give you thanks and we give you praise in Jesus' name. Amen and amen.